I want to start with a very important announcement. I just 5 minutes ago got a text from my daughter, who is 11, that says, Giants 5-0. And I want to thank everyone for coming. I have to finally learn a lesson about the TV schedule before scheduling this. 2 years ago, we had the last game when the Giants won the World Series. During the middle of it, we heard cars honking, and we all knew they won. So, and of course, the presidential debate. And really appreciate you all coming out. I think it's a sign of how important this topic is and how many questions there are to have everyone. We have our guest Laura. It's kind of a funny story. It's a funny enough story that I'll tell it to you, which is I was reading a New York Times article on the recent case where the FTC got fines against music websites for Selena Gomez and others that were collecting private information. It was in the Times. I was reading it, and then they had a quote from the director of the FTC responsible for all this stuff, and I read the name and my jaw dropped because it's my cousin. And I've known him all my life, and I knew probably 15 years ago he worked at the FTC, but since we got into kids apps, I never put two and two together to realize he was the director of all this stuff that we've been tearing our hair out and wondering about for months and months. So I wrote him. His son lives in San Francisco, and I invited him to come speak, but he couldn't make it, so he very kindly pointed us to Laura, who has graciously agreed to come and give a presentation. I know there are going to be a lot of questions. I fielded a lot of questions, and we've typed up questions people have emailed. As we get to the end of Laura's presentation, we can decide if we want to actually dive into those or have it more free form. I'm open to whatever. Before I pass the floor to Laura, we generally like to just go around and quickly introduce ourselves because it helps, I think, Laura know who's here. It helps you know who's here. If afterwards you want to go to someone and say, oh, I'm interested in what you're doing. So just a real brief introduction, and we go around, that would be great. I'll start with myself. I'm Josh Garrett. I'm your host for the New Faces. My company is called Creativity, and as you can see, we work in the toy industry. We've been doing toys for 12 years. We're hired by people like Hasbro, Fisher-Price, Mattel to do content for their toys, electronic toys. So we script them, we write the play patterns, we record the voices, we program them, all of that stuff. We've contributed to over 5,000 products, many of which you probably have seen and have probably driven you crazy, but we love them. And a couple years ago, we started this meetup because we were getting children's apps ourselves. We have our own out there called Doraemon 123, and we also have some out for some of our clients, which I wish I could tell you about, but we signed away our and we're also about to release some more, which some of you might know, which is called Rocksters, and the name is still impossible. So that's us, and I will pass it this way, and we can just go around, say hi, and introduce yourself.
Sure. So we're a startup called Funloop. We started just actually a couple weeks ago. We've made games before, but have not made any kids games, so really excited to kind of learn the specific kid rules.
I'm Vanessa. I started the company with Taylor. We're starting with toddler games. So a little bit.
I'm Harish. I work at Yogi Play, and we help parents find educational apps for their kids in all over the places.
So I'm Michelle. I'm Yogi Play, and
Hi, I'm Gail. I'm from Social Backlabs, and we make educational games for kids. We're targeting 4 to 7-year-olds.
Hi, Iran, work with you.
I'm Carla with Penguin Mobile. We are in the hardware space.
I'm Bill with Wonderful Interactive Storybooks. We're bringing back the title some of you might remember called Living Books from years ago. And prior to Wonderful, I spent many years with a small brand called Hello Kitty.
Vincent Tong. I used to make video games at EA for 9 years, mostly online games, from children to Star Wars. And I left EA back in April to start a toy company to basically with app-enabled toys.
I'm Ann Collier, and I run a nonprofit called netfamilynews.org. I'm a journalist, and my other hat is connectsafely.org, which I co-direct.
Hi, I'm Rudra. I run a game studio that does iPad, iPhone games. We do casual games. I focus on positive and educational games. So that's it.
Hi, my name is Francisco. I'm head of engineering at Curaptive. It's a startup that we just launched, I would say, three weeks ago in 4 countries. Our kind of a interactive story-based app. There's going to have several episodes, as we call, and we're going to launch this in the U.S. and actually I think it's going to be worldwide in December.
Hi, I'm Mirjana. I used to work at Nokia. I'm co-founder of a startup called Kindoma, Kind Child, Oma Grandma, and it's a website for grandparents to read books to grandkids. And I'm very interested in how to make it right.
Hey, I'm Harish, the other Harish, I guess. I used to work at Kaban making Facebook games, and I quit my job, and I'm about to quitting my job and starting my own startup for making kids games as well, educational games as well.
Hi, I'm Anu from Anusen Inc. So me and my husband started this company. So we do educational games for kids. So it's targeted from preschoolers to 3rd graders.
Hello, my name is Kevin, and I'm here to learn more about this topic. We make interactive stories and games based around the Bible for kids.
Hi, my name is Raj. So I was the co-founder of a startup called Togetherville, which was a real-life social network for kids. And we were acquired by Disney about 1.5 years ago. But I still love the space, still learning more. So I'd love to hear what you guys have to say about Kato. So.
Hi, how are you? We're the one who came from Korea. And yeah, we're thank you. Yeah, my company's name is Cotton Interactive, and we have made like 100 apps for kids and total 10 million downloads. And we are winner of the bestseller 2011 of App Store, and we are third ranked in world most influenced app company in education category that Google announced. And we try to expand our market to United States. So yeah, we need you guys. And if you guys have any question for the market in Asia, yeah, just feel free to ask me, and yeah, I'll let you a lot of information for you guys.
What's your company name again?
Cotton Interactive.
Cotton.
Yes, Cotton. Thank you.
I'm Jessica. I work here at Creativity as a producer, and I produced Dermy 123, which came out last year, and working on our new app for Raptors.
I'm Matthew. I work here at Creativity. I'm on the programming team.
Hi, I'm Alberto. I'm co-founder and art director at Jogomi, which is a startup that develops educational games for kids.
Hi, I'm Melissa. New to this space, so just curious about what I need to do to be able to get started.
I'm Irene. I'm actually a developer at a company called Autodesk, but I'm also an independent developer just interested in creating educational apps, particularly for special needs.
I'm Mike, and I have an astronomy application in the App Store right now called Distance Sense. It's been out for about 4 years on the App Store. And this is its 25th year of release on any platform. So if anybody's using astronomy content for some of the books or things you're working on, give me a shout.
I'm Josh. I've worked in online games, Facebook, mobile, worked with Kabam as well, and just learning about the space, interested in making some content that's a little more educational and rewarding than just general.
My name is Matt. I'm a usability engineer. Most recently, I consult for my friend's company called DigiNew. We're looking to do educational technology, and so we're trying to take learning content that's already available in classrooms and make them interactive and gamified for kids.
Hi, I'm Claire. I relocated from London about 6 months ago. In the UK, I used to edit magazines for children, mostly for the BBC. I was very excited when I was on an iPad and just went through and brought out an interactive magazine for girls called Lily. And really, I'm here looking to meet other people who may want to put some of their content into my magazine. So effectively, it could be a magazine on the iPad, but it's actually a fast idea.
I'm Laura. I'm from Canada, not quite as far as Korea, but visiting here at the Plug and Play Accelerator with my company, Mulberry Media. I create apps as well for children and parents. My most recent and first launch was August 1st, and it's called Mulberry Finger Plays, which teaches children how to do things. Finger plays are like the itsy bitsy spider on the floor. So there are hundreds that parents don't know about, and so this is just at the touch of a button you get to see what they are. And there are an awful lot of people I'd love to connect with at the end of this thing. So thanks so much for making it happen.
Hi everyone, I'm Janice. I'm also from Canada. Laura and I were here in May with TechLoom in Canada, and now we both have moved to the Valley. My company is called Just Be Friends, which I actually match children and their parents, and they create their village, and they go to a private backyard to play. So if you have games, you could use my interactive portal in order to connect with those families and kids. My claim to fame is I was chosen by Oprah as her ultimate viewer and went to Australia with Oprah. And now they're doing a follow-up. So I need to get this pivot towards children going. So I'd like to meet all of you because I'm sure you're going to give me a lot of information before that next Oprah show. So thank you for having us. And I'm actually leaving now. I'm going to the Okanagan, to the accelerator there, which Club Penguin, which many of you know. They house an accelerator now in the Okanagan Valley, so I'm heading there to be mentored by the Club Penguin founders. So that's a big deal.
Hi, I'm Susie. The name of my company is Mia, and we build bilingual storybook apps on the iPad and the iPhone.
Hi everyone, I'm Michelangelo Caparo. I have a company called Cadoodle, and we make creativity apps for kids.
Hi, I'm Frank Collin, and I work with a lot of app companies doing some business development and marketing and advising. And on the table out there, you'll see a little notice about a little workshop we're doing with a number of our children's app authors this Saturday in the city. There's a 15% discount for anybody who's here tonight, and hope some of you like to make it. Thank you.
I'm Nancy McIntyre. I'm the founder of Fingerprint. We're a mobile network for kids and their parents, and we work with third-party developers, so hope to meet all of you.
I'm Heather Regan, and I head up product at Fingerprint. We're going to meet all of you guys.
I'm always blown away by the amazing talent that comes from this. It's fabulous. Thank you all again. And without further ado, I'm going to turn it over to Laura to talk about Hop.
Hi, everybody. Can everybody hear me okay? It's not that big of a room. I heard all of you just fine without a microphone. But so as Sean was saying, I work for the Federal Trade Commission. I actually primarily do law enforcement. So I enforce certain federal laws that protect consumer privacy. I do not, however, happen to enforce CAPA. Others at the agency do. But I moved here from Washington, D.C. about 2.5 years ago. And since that time, we have a relatively small office in San Francisco, the FTC does. And so since that time, I've been pretty involved in doing a lot of outreach, coming to events like this and other conferences. So I'm very interested to be here to address your concerns and hear what kind of questions you have, and really super interested to hear what you guys are all working on and the challenges you're facing. So today I'm going to say a few words about kind of generally what the agency does, because I think a lot of that's helpful background. Seeing the questions that you guys had made me realize that some of your questions maybe aren't exactly CAPA questions, but they're kind of questions like, could we be doing something that might be maybe illegal here? So I want to give you some of that context before we zero in on CAPA. But I think for me, it's fine if you guys want to jump in and ask questions, but it might be good to get some of the general background kind of rolling first. Okay, so the FTC enforces a lot of different laws and statutes, but one of the primary law that we enforce is just something we affectionately refer to as Section 5, kind of a pet name we have for it. It's Section 5 of the FTC Act, and it prohibits unfair and deceptive acts or practices. So something is, let me see if I put something else in here. Yeah, we'll talk about this in a second. We have a bunch of other laws, including CAPA, which we're going to really focus on, but we also have sectoral privacy laws that protect particular types of information. So, CAPA protects kids kids under 13, and there are other laws that protect credit report information. If you're dealing with any of that, or financial type information, also not really relevant. So the Section 5 statute, actually we do often allege violations of Section 5 in tandem when we find a COPPA violation. It's often both. And the reason is because, so Section 5 requires that you honor your promises, including your promises about privacy. So if you say, hey, here's a privacy setting you can use, that's a promise to keep that information private. And interestingly, in a case I worked on, a case against Twitter, we also said, hey, if you have a privacy setting, that's also a promise about security. You're promising that you have at least reasonable security to uphold that. So you want to be really careful. In the COPPA context, it's often what you're required to have a privacy notice that explains what you're doing with kids' information. So it's often in a COPPA case, if there's a deception allegation, it's often that you didn't live up to your promise in your privacy notice. But it's just good to be aware that other things where you're not explicitly stating something in a privacy policy, that also might be a promise that we would seek to uphold. And then for unfairness, those are practices that are likely to cause substantial injury to consumers that they can't reasonably avoid and that aren't somehow more beneficial than they are harmful. We have put out some advice for mobile apps recently. If you want to order these for everyone in your organization, you certainly can. There's a website handy for that called bulkorder.ftc.gov. They're free. You can also just check it out online. I was involved in writing it. I did not choose this graphic, which to me always looks like it's sort of disintegrating. It's not a reassuring image, but you guys see this? Okay, it's a little dark. Yeah, you guys can see it fine. The laptop's a little darker. So basically, it just runs through in some detail what some of your obligations are, and also talks about best practices. So obviously the first one, telling the truth about what your app can do, is obviously a legal requirement. You have to be truthful. So, and to that end, you're going to want to focus on making your information clear and conspicuous. So a lot of times when we've alleged companies have said something that's deceptive to consumers, the company said, but wait a minute, if you look down at the bottom of our policy in the fine print, we've said exactly what we're doing. And we have had cases where we said that's not enough. If your user licensing agreement or your privacy policy makes an impression at the top, you can't have a little fine print disclosure at the bottom that contradicts that. We might allege that to be deceptive. And then this next one is really important, but is not necessarily a legal requirement. This is more of a policy initiative that's very big at the agency right now, privacy by design. We're just really advising everybody to do this, but I think in the kind of electronic space, it's pretty important to, it's saying things like make sure that you have a plan to only collect the information that you need. So you're not collecting all kinds of information when you don't have a plan for it, and you have a plan for how you're going to delete that information later when it's outlived its useful life. When you're no longer using it, those people are no longer coming to your website anymore. You maybe don't need to keep their information. A lot of people have educated me to understand, hey, if you don't make a plan to dispose of information, you're not going to be able to get rid of it without breaking your app later. You can't just go in later and try to, delete things bit by bit. So one of the things that we've really said is you need to build privacy in by design from the beginning. And that's a best practice. It's also something that we have in this information security context. I think you could say that's something that we've looked at a little bit. So all of the best practices can help you stay on the right side of things in the enforcement context too, and they're just good policy. And these other things are similar best practices: to be transparent and offer easy to find and easy to use choices. There's no federal requirement other than COPPA that you post a privacy policy, but there is a requirement in the state of California. You have to have one anyway. So you want your your privacy policy to be clear. And probably, how many of you heard last February when the California State Attorney General entered into an agreement with the major platforms like Apple and Google and Microsoft? Did anybody hear about that? Okay, so a few people. So that was all about exactly this. A lot of apps said, hey, we're required to post a privacy policy, but there's no space for us to do it in the App Store. How are we supposed to meet our state law obligation? I mean, I don't want to waste your time hearing me talk about state law because I do federal law enforcement, but just for interesting background. So all these platforms said, well, we're going to do a better job. We promise we're going to actually make it easier, give them a space to post apps to post their privacy policy in the App Store. So I don't know if any of you have noticed that, but different platforms, I see some people nodding heads, starting to make better spaces for that. So while there's not another general federal law about privacy policies, you probably have to do it anyway if you guys are doing that, and the state of California requires it. Okay, and you guys, we recommend collecting sensitive information only with consent. And again, it's not that there's a federal general requirement to get consent for sensitive information for users at large. There are consent requirements in COPPA that we're going to talk about, but it's a best practice. You could surprise users, or they might not understand what's happening, and that can get you into some legal hot water if you're not perfectly clear. So whenever you're, just keep in mind if you're doing something that a user might not expect, you want to make that clear, and that could include getting consent to collect sensitive information. And of course, you want to keep user data secure. We have had over 35 cases where we allege that companies violated the law by having inadequate security, either because that put consumers at risk for something, a harm like having their financial accounts compromised, or because the company had promised to do better than that, had said, we have reasonable security in that. That's the kind of general context, and you should just keep that in mind when figuring out, hey, what's the best thing to do and what am I required to do? You might want to just try to do some of these best practices because they can really just advance a lot of your goals. Okay, so now let's turn to COPPA. Everyone is looking so serious now. The more I was mentioning these cases, everyone's like, even the debate makes me feel better than this. It should be actually informative and not too combative, and you'll get real information from it.
We're just thinking about the work that is going to be
Yeah, I mean, hopefully these are all things that help you incorporate these principles into what you're doing overall. And these aren't just going to add kind of, meaningless or fine print obligations to weigh you down. These are really meant to be things that will improve your business model overall. So, so COPPA is the only child-specific federal privacy law in the U.S. And here's the requirement you guys are probably the most familiar with in COPPA. It requires you to, if you operate a website or other online service, you have to notify parents and get their consent before you collect personal information from kids under 13. And I take it quite a number of you are doing that or are interested in doing that, so you're probably complying with COPPA already, but I know there are some people who are just thinking about collecting information from kids.
Yeah, I have one.
Oh yeah, sorry.
When I was doing some of the research, I noticed some of the sites that say that you have to get the parent's email. I'm a parent of 2 children. I literally lied my age, sorry, but I wanted to see if I could break into these sites where it said it required the parents' consent to be part of it. All it took was just making up an email and sending it to them, and all of a sudden kids were in there. And it was really scary to me because the amount of friend requests I had from just total strangers, even though it said I had their consent. Is there any way around that, or that's just only...
So it's interesting. So there are a number of methods. I think you're asking about the methods by which you get parental consent, and the rule is pretty specific about those. So, I mean, your question is not really like, what does that really mean? Your question is like, well, gosh, aren't there some ways that people can get around this? And so the Email Plus, which is the consent mechanism that you're talking about, where parents consent by sending back an email that has some additional information in it to demonstrate that it's a parent. That's actually, and I don't want to talk too much, we're in the process of proposing revisions to the COPPA rule, and under the current rule that's an acceptable method, but that is, and for a lot of the reasons that you're indicating, I keep wanting to call you over now. What was your name? I'm Janice. But some of the things that Janice was saying, for those same reasons, like the proposed revision was to do away with Email Plus, that it's not strong enough, and it's not actually a method that a ton of operators rely on, but it did, in response to a proposal to do away with it after all these years, suddenly a lot of people, as I understand it, came out of the woodwork and said, no, we love Email Plus, we think it's great, and it's doing the job. So that's one of the issues that's under consideration. That's under consideration right now. So yeah.
Hi. A question regarding just outside the U.S. I know you're here to speak for federal, but obviously for a lot of us, our audience is worldwide. When last time I worked on a children's online game, at the time there's a lot of different rules in Europe, but the ones that's most established that people fall into in general is COPPA, right? Can you speak to, let's say in Europe, for example, are they coming up with their own standard? And I'm not going to hold you liable. I just want to see what's your opinion.
The short answer is yes, that Europeans have their own standards for privacy in general.
For all EU now?
Yeah, I don't know I mean, there's this is very general, and don't rely on this, please. But in general, the European privacy authorities have their own standards for how to notice and when you need to give choice, and whether you can use information. You can't use information for a purpose other than what you collected it for without getting consent. And if you want to transfer information to the U.S., because our privacy laws are different, you actually have to participate in the safe harbor program. So actually there are different standards already between the U.S. and European privacy authorities. What I don't know is if there's anything specific going on with regard to kids' privacy in Europe. I just don't know the answer to that. Yeah.
So my question was on the previous slide's definition for personal information. I haven't been able to find a really good definition of that. Can you give some?
Let me go to, I'm going to try to go back and forth, even though I'm not very good at this. Hold on. I don't know how to skip ahead to, this is giving away all the suspense. Here. You guys will get a hold of this later. And it's right in the rule, too. So I put this at the end because it had the proposal in it, and I don't want you to think about that right now. That's a proposed revision. That is not what you're, so only look at what's on the left right now. What personal information is, it's your full name. So if you're just collecting, for example, first name, you're saying, Janice likes polar bears, and so we're going to market to her something that shows a picture of, a personalized polar bear that says Janice across the front. You haven't, under the current rule, because you didn't collect a full name, it's just a first name, it's actually not considered personal information. But what's happening, there's some discussion of whether to expand the definition of personal information to cover other persistent identifiers, and then of course first name would be encompassed. But under the current rule, and the one that's been enforced like full time for more than 10 years, full name, physical address, email address, security number, telephone number, a screen name that reveals your email, a way to get in touch with you, or any persistent identifier that's combined with any of these. So basically, you can collect, if you collect a persistent identifier, so just your own persistent identifier information about activities on your site, and you're not identifying it, you have not collected personal information under COPPA. But if you later take that same information and you identify it, it makes all that other information into COPPA-covered information that you need to notify and get consent for and give parents the right to access and delete. Does that make sense?
I just want to reiterate, I'll post this presentation for everyone afterwards. You don't feel like you have to write it.
Oh, thank you. Well, yeah, and this actually does come straight from the text of the rule. I know rules are not as friendly as I tried to make the slides, but yes. Okay. And was there another question right now? Yes.
question I have is, you said that as far as you don't capture the full name, then that shouldn't be considered personal information. But what happens if you're just, I mean, you're offering a free-form text field in your application? So do we have to kind of, process that field so we make sure that there's only one word there?
Yeah. So if you have a child-directed site and you're providing kids with a way to make personal information public, that's also a triggering event for COPPA consent. So you'd really want to be, if you're a child-directed site, you'd really want to be getting parental consent for that. You'd want to be notifying them and getting their consent. If you are a general audience site, but none of you guys are, then it's a little different how you deal with like chat rooms and public forums and things like that. But that's not the situation with any of you guys, right? You're all child-directed, kid-directed. Okay.
Yeah. So, with the App Store, you have ways to specify. So this is a little more focused with COPPA and the App Stores that people deal with. And, it seems like if I'm making games for little older kids, I could almost say the games are for 14 to 16, right? And then by the letter, it's above the
Then
roof.
it's no longer kid-directed. You have explicitly said this is a site directed to older kids. We will still look at your site to make a determination that's fact-specific about whether we agree that it's kid-directed, but of course we would consider that. And if you are screening out kids who are under 13, then that we would, that would mean you're not a kid-directed site.
It's got to do with the dynamic of app stores because kids sort of download all kinds of stuff. I don't know if there's maybe what I should be asking is if there's information for the app developers and the App Store and COPPA.
Yeah. So let's talk about the general audience versus directed to kids and see if that answers your question, and then we can come back. Yeah.
Just on the other side, you said personal information that's connected with other information.
Yeah, so there was an enumerated, when you guys see that list later, there was an enumerated list that I went through. It had like 6 items on it. So it was your full name, a screen name that lets you email, your address. If it's not on that finite list of information, it's not personal information under COPPA unless you combine it with an item on that list. So the deal with it is if you've collected a lot of information about behavior, or say you've collected photos under the current rule, photos are not personal information. But you later attach a full name to it or attach an email address to it. So you attach a piece of personal information from that list to the other information, that makes that covered as personal information too.
By attach, does that mean that I can go back and know that that image belongs to that email address?
Yes.
Or that I actually combine it together and present it with that personal information?
Yeah, no, it doesn't have to be that you just close it. It's that you are actually just associating it. It means that you are collecting the personal information. So
if you have an application that allows the kids to take a photo or something,
yes,
and then you can email it to someone, you can enter an email address and through your application email that photo.
Without revealing your email address. So the question is what if your app allows kids to email out photos that they upload? And you would do that without sharing the child's email address, for example.
I guess in some cases, I guess it depends what mechanism you use.
Yeah.
If you do it in iOS, then you usually do it through the person's email account. The owner of the device.
Right. So if you associate, then it makes it into personal information. So that's right. That's a great example.
Except you don't collect it.
You don't save it in any way.
But if you're providing the way, I understand. But if you're the one providing the way to make that public, that's also a triggering event on COPPA. So that's important to highlight. That's good. Yeah.
So just reiterate. So sending out an email from an app for kids, so that triggers a COPPA thing, is it?
So if you are letting the kids send out their information, yes. Yeah, you're creating the way for them to send out their information. There's a discussion of that in the rule, and that's actually one of the activities that's of most concern to parents is like putting their kid into contact with people that they might not know, where they can communicate other information that you're not controlling. So that's one of. I mean, the COPPA is not saying that you can't do this. That this is like it's saying you need to alert the parents that it's happening and get the parents' consent. But yes, that's one of that's right. Okay, basically the COPPA covers sites. Did you want to, Josh? Did you want to?
I just wanted to mention, I think you saw a lot of information. So if you have a question you think might be answered, hold on to it, and we'll have time at the end.
COPPA covers sites that are directed to kids, which it sounds like most of you guys are, that either collect, maintain, or provide the opportunity to disclose the information. So collection, you guys all understand what that is. We just went over it through an example. That's really good. You guys are asking questions that help illustrate this, so that's great. What it means to provide a way to disclose. And maintain would be like somebody else might be collecting it, but collecting it on your behalf, and you're the one who hangs on to it. That just means you're an operator too. Okay, and then an operator of general audience site, if you have actual knowledge. So in the example that was given of a site for kids 14 to 16, if you ask questions, there are examples of information that might give you actual knowledge in our cases and in the discussion of the rules. So it's things like, well, if people submit their date of birth, you have actual knowledge now that they're under the age of 13. And we've had cases where the site said, no, we're not for kids, but they were collecting birth dates in the registration process, so they did in fact know. It might be other age identifying questions. It might be, a question, are you in A, elementary school, B, middle school, or C, high school? Choose one of the above. And if someone answers A, you know that you have a child registering through your site. So things of that nature. And also, if a parent contacts you and complains, you want to have very good mechanisms for that. If you think you have a site for dealing, processing, and becoming aware of any complaints that you get from parents, it's really important, because if a parent contacts you with concerns saying, my child registered for your site, you send you an email, we would look at that email and say, you had actual knowledge that a kid was on your site, and we would expect you to have deleted that child's information or, acted in a way consistent with the parent's wishes with that child's information. Okay, any other questions? And you'll have this whole list of the factors, so I won't read all these to you because you'll have this whole list of factors, but we just look at the site and see, is this the kind of site that appeals to kids? What's it about? What kind of figures does it have on it? How old are the models? And we would also consider any evidence there is about who does in fact use the site. And we propose to explicitly make it a factor to say music and celebrities appealing to kids, but making that explicit, we already consider that because that's part of how does your site look and feel, just to make it more authentic. Okay, and then this was an example, this was a W3 Innovators case. It was our first mobile case where we said that this Emily's Dress Up site actually was collecting information from kids and letting them post it publicly without complying with COPPA. So kids could sort of post their public feedback on what Emily was wearing and communicate with other users about it and save and write to Emily through the app, and they weren't complying with COPPA. Skitty Kids was a social networking site for kids, again not complying with COPPA. The general audience I've told you is already, here's how you have to have actual knowledge, and here's how you might get it. That seems pretty clear, right? Yeah. Okay, and then here are the things operators have to do. You guys can ask questions about any other area too, but here are the things you have to do. You have to have a privacy. I think these things are all pretty clear, right? We have a great education piece about a checklist for writing your privacy policy. That's pretty helpful. But you have to post your privacy policy and links to it wherever information is collected. You also have to directly notify parents, consent before collecting information, with some exceptions for collecting contact information for certain purposes. How many of you believe that you may be using any of the exceptions for collecting contact information from a child? There are things like if you, no one's raising their hand, but many of you look perplexed. So there, yeah. So you are all you have to get prior consent, right? But you can't get prior consent before you get the parent's email address from the child to email them. That is an exception. So all of the exceptions are not exceptions to notifying the parent, but they're the exceptions to getting prior consent. Another example, and they all involve contact information. If you want to get the child's contact information to respond to a one-time direct request from the child for a particular response, you can respond to that before you get parental consent. And a lot of people have used that for, like, to run a one-time contest or something like that to get back in touch with the child if they want. But you can't collect other pieces of information. It's just for that one-time use. So those are the kind of examples.
Just about the contact information.
Yeah. There are a few different ones, and one is the parents getting the parents' contact information, and another example is getting the child's contact information for a single use. So if you think that you have a reason to get back in touch with the child, check those exceptions. That is the takeaway from that. I don't think you all need to try and memorize all of those. Okay, and then you also have to give parents an opportunity to access and delete kids' personal information or to opt out of future collection. How many people are already doing that? Are there any issues or how often do parents get back in touch and want access or deletion of their information? Is that like never? Yeah, I'm seeing people not. Yeah, I just was wondering about that part of the rule, whether that's an active area, and it sounds like maybe not. You have to limit collection of personal information. So basically, under COPPA, you should not ask for more information than is reasonably necessary to engage in the activities of the site. So if the goal of the site is to play a game involving uploading of photos, you shouldn't ask the kids for other demographic information about themselves that has nothing to do with that activity. And you certainly should not require it. You cannot require it. And then you also have to have reasonable procedures to protect security. That's a COPPA requirement too. And we've had one case about data security, the RockU case that we recently had, where we alleged both COPPA and the FCC Act were violated by falling short in that security area. Questions? There are some safe harbors. If you comply and get certified that you are in compliance with any of these approved safe harbors, then we would regard you as being in compliance with COPPA. A lot of smaller companies, just so you know about that.
Just a quick question.
Yeah.
Trustee is one we've used before in the related website. Their policy is that as long as you have a policy and you adhere to it, they're okay. They have no specific guidelines on how much privacy you have to have.
And I don't know if you're. I actually don't know the safe harbors at all. These are the ones that are commission approved. But when you are trustee, I do happen to know, and I'm no expert, but they have other programs other than COPPA compliance. I'm not completely sure.
Yeah, this was general.
Yeah, they offer other seals and compliance programs. So hopefully their COPPA requirement does more, because I don't think the commission would have approved that. Yeah.
I can actually tell you that we've gone through PREVO on COPPA compliance approval, and it's a long process.
Yeah.
It's been a long, excruciating process, but we did get there. So it really takes time to actually look at every single thing on your site and every single detail that you collect.
Yeah, they really want to make sure they're.
Are these paid services? How does that work?
Yeah. To be honest, I think it is a paid service.
Is there roughly how much it costs?
So I actually went through the trustee process, and it's a very detailed process.
Trustee is another safe harbor.
Yeah, safe harbor, and it was $1,500 a year was the charge for the certification through trustee specifically. This was about 2-3 years ago.
How much?
$1,500.
It probably depends on how complex your operations are. And companies can be. I mean, we had a case where, and this was also a case that I did, but where we alleged that a steel company violated Section 5, that it was deceptive because it was promising to do verification and giving consumers confidence by putting its seals on websites, and it wasn't doing all the verification it promised. And so these companies that are, making these promises on your behalf, they have to be really careful because they could be on the hook under Section 5 if they're not living up to what they should do.
Has anybody thought about whether it's cheaper to just hire a lawyer in the long run? I don't know. I was just,
Well,
$1,500.
Yeah.
It's supposed to be cheaper to get to Harvard, right?
If you are found to have violated COPPA, it's up to $16,000 per violation. But we have different factors that we use to calculate the amount of damages. Like we would certainly consider things like, how serious of a case was this? Was this, a really ongoing long-term thing? Did they respond when they should have, when someone alerted them to the problem? Things of that. Was the sensitive information that was collected or really just incidental? So not everybody pays that amount, but some of the penalties can get quite high.
Wasn't Zynga hit with like $1 million penalty? It almost put them out.
That's not. Zynga was a while ago.
Yeah, that's a social network. It's a website, not an app. But
yeah, more recently we've had ones that are, a few $1 million. Like Playdom was $3 million. Zynga was, I feel like that was like maybe 10 years ago. But now, anyway, so.
I don't know about that later. How do you prioritize who you look for? And how do you make the filters of the sites you can go after?
So, COPPA is actually different from other privacy enforcement that we do. So the privacy cases where I do enforcement, a lot of times we don't have consumer complaints because consumers have no idea what's happening with their privacy and who's getting a hold of their information. So for those cases, we rely on researchers, news articles, our own undercover work when we test how apps work, and we look at the web traffic, like, when you click an ad, is your user ID being transmitted to this advertiser? What information is actually being passed? COPPA is different because we have very strong complainers, the parents, who, if something's going on, I think certainly play a role in alerting us to cases. I don't know how else the folks who do COPPA enforcement find the cases. Certainly there's some review of kid-directed sites, especially recently, to see if they're complying. Like you could go through and do an undercover registration for the site and play around with it and see if they're complying. And this just tells you we've had 20 cases overall that became public. We've also had some cases where we wrote closing letters. We said, hey, we see that you're doing this, but this isn't personal information under COPPA, or we're not going to take further action at this time. We don't usually give reasons, but in 20 cases we did reach settlements and get, among other things, penalties. And you'll have a list of the kinds of penalties we usually get. 16,000 I mentioned per violation. We also require usually the company go back and delete all the information that they got without the proper consent procedures in place, so you can kind of be starting over. And then you have to do some usually internal rebuilding of your employee education process for running your collection operations. Everybody who's under order does a compliance report to us. And a lot of times, I guess, in the COPPA context, this isn't always in our cases, but in the COPPA context, we require some consumer education, so you would probably have to say something on your website about what you were doing and why.
Per violation is per individual?
Yeah. Yeah, each time you did it could be considered a violation. And so this is the same amount of penalty that we would use if you sign an order. So once you're under order with the FTC for any kind of law violation, the statutory damages for violating the order is $16,000 per violation per day. So we have an order on a case I worked on against Facebook, and we have a settlement with them, and that could be very, depending on how we looked at it, if they did a violation, and it was across their site per user per day, it could get very large very quickly. But we have discretion in how we enforce that. We don't it's not just a robotic thing, but it can really add.
Does it include users outside the U.S.?
For civil penalties, that's a really good question. Because I don't know of a case where we have done that. Certainly, they could violate the order through the. I don't know how we would count that actually. Yeah.
Do you actively shut things down, or how does that work? Is it more just fines and then?
So it depends on the context. So typically in the privacy context, we're not shutting the site down. The site has done something that didn't live up to what it intended to do or what it was supposed to do. Sometimes in the privacy context, a weird thing has happened that a company has just changed its mind about what it wants to do, and we've been in the position of saying, actually, you promised not to do this, so you can't change your mind. You can't, one of our big things is you can't retroactively change your privacy policies. You collected it under one set of promises to consumers, and you have to stick with those. So in those kinds of cases, we're not coming to the company and saying your business is fraudulent and has to be shut down. We're saying, listen, these practices, which are just a part of what you're doing, are unlawful, and you have to refrain from those practices. So lots of companies, like the Facebook and Twitter cases that I mentioned, and these COPPA cases, many of them, the company was left intact. Some of them did not have COPPA procedures in place. I'm not sure what ultimately happened to them.
So, I'm sorry. So are you not allowed to change your privacy policy?
Yes, you can change your privacy policy. What you can't do, and this is Section 5, this is not a COPPA principle, you can't do a material retroactive change. So you can't say, hey, we're collecting your information, but only so that we know more about you. We're never going to sell it to anybody. And then a couple years down the line, decide, we're going to change our privacy policy, and we are going to sell that information that we collected under the previous promise, right? Because that would be retroactive because you didn't go back to those people and get their consent. But you can change going forward prospectively. You can change your business model as long as you're complying with your COPPA and other legal obligations. Okay. This is a picture of the Selena Gomez site from the case that Josh mentioned earlier, one of the fan sites that kids were signing up for without complying with COPPA. This was another information where kids were signing up to get fashion and brand updates about certain types of clothes, and they ended up having actual knowledge that kids were participating because they collected dates of birth. Here's your slide with personal information. I don't know. I'm inclined to take questions before we talk about any of the proposed modifications, because the deal is, so we started, COPPA took effect in 2000, and we started in 2011 a proposal to revise COPPA to make sure that it continues to protect kids, even though a lot of online practices have changed. And it's been a long process. There was we got 300 comments in response to the 2011 proposal, and then we did a supplemental one in early 2012 and got another 90 very strong comments about that. The commission is a 5-member body, and it's not clear what is going to be the result of those. So I don't want to with a peaceful sense that you know what the current law is and not be too concerned about that unless anyone has particular questions. Yeah.
So I have 2 questions around sharing non-personal information with third parties.
Right.
So my 2 examples would be an analytics company to help track and aggregate personal information we're tracking about our users, as well as advertisers. So a number of advertisers in the mobile space require you to give a identifier that says that this user actually did install your app.
I want to come back to that second question. So let me answer the first one. So the first question is, what about if you are disclosing non-personal information? So it's not one of the enumerated, those first 6 items on the list. It doesn't include that. It's not combined with that. It's other information like behavioral information about your site. So, for example, advertisers could know, hey, here's the site where the page where the most people go, pay extra to have your ad on this site, or something like that. Under the current rule, when you disclose anonymous data, meaning it doesn't contain any of those first 6 factors, it's not covered by COPPA. That is not a triggering event under COPPA.
Would you say not the current rule?
Yeah.
What's that? I'm
Would you
sorry?
say not the current rule? Is that intended to be? Sorry.
No, it's important. So in the 2011, in the current proposal, there is an initiative to cover persistent identifiers. So if you had a user number or other, like a cookie ID or other identifier that said who specifically someone is, that would be covered. But it sounds like, in the example that was given, it sounds like you wouldn't even be giving aggregate data. So that's still going to be, even under what was proposed.
Well, is there a default to that? So
Yeah, and then I'll get to your second question. I could have you tell me it again.
So if you do have some ID that tells you which device it came from, they call and ask to remove themselves from the system, they have no idea who they are.
Right. And that's kind of a note. Yeah, so
What was the
one
question
question that has come up, this is the proposed rule, and this question is pointing out that if persistent identifiers become personal information under the rule, it may be difficult to carry out some of the operator obligations with regard to that, because you might not know, for example, what information to delete if the parent has it. And I think that is one of the issues, like the kind of feasibility issues that they're considering, because one of the key things is that you get to give consent and make a choice about collection in the first place. So, yeah. What was the second question?
So my second question was sharing a persistent identifier with a third-party advertiser, so that basically on the mobile space to figure out if that user has installed your app when they showed that person an ad. And so the traditional way is you share their user ID from the Apple phone, and you say this person installed the app. Did you show them an ad? And they say yes or no, and then you pay for that install because they provided an install fee. So I guess is that sharing that personal identifier to a third party if you're marketing to a kid.
So right now, that is not, if you are not combining it with one of the 6 items on the list, hopefully it's reassuring and not boring that I keep repeating this. Let me tell you again. If you are not sharing one of these 6 items on the list, meaning actual full name, it is not personal information.
It's possible that they are, we wouldn't know.
Yes, that's right. So it's possible that someone else is going to use some mechanism to re-identify the data, and you would not know or be responsible for that unless, if it were happening through your site. So say as somebody present on your site, the kids are entering in their name and their address and their social security number, whatever else is on the list. They're entering that into your site, and somebody else working in tandem with you on your site who has some sort of presence on your site is collecting through you. We might think that was something you should have been responsible for. You need to understand they're an operator too, and somebody would be needing to make a disclosure on their behalf. So, yeah.
For these 2011 proposal, you said that there was like 90 comments.
There were 300 on the 2011, and then 90 there was a supplemental one kind of trying to clarify some things.
Can anyone make comments? How are these comments collected?
This is the same actually across all federal government rulemakings. There's something called the Federal Register, and it's just where it's this like crusty old document. No, it's a very dynamic online site. You can look and see whatever government actions are taking place on the public record. And so when we propose to enact the COPPA rule and issue the final rule or propose revisions to it, it takes place on the public record, and a comment period is set out. We say, we'll take comments for the next 60 days, and then we extend it. The COPPA one got extended many, many times so people could get their comments in. And after the comment period closes, at some point we have to move on and take action on the hundreds of comments we've gotten, and the comment period is actually closed on that rulemaking. I don't know if someone has specific comments and they send them in. Often people will use their discretion to try and consider those, but in that case we have to make it public. We have to make all the comments public. Anything the commission is considering, like if one of the commissioners meets with a company and the company says something about COPPA, we have to make that public.
Anyone was commenting, or is there like the company that put weights on it?
No. They actually really like to get different perspectives. So, if somebody writes in and one person's a parent and one person's a school teacher and one person's from a big company, what people would reasonably think is, wow, these people have all different perspectives, and really be glad to get those. People do not want to only read perspectives of one group, whether it's large companies or
if this passes, is there any way to appeal, or has it ever been reverted, or?
Yeah. So I guess if you want to, there's not an appeal. We have the power to enact COPPA regulations, I guess if someone thought, wow, you exceeded, we don't have general rulemaking authority. We can't decide, hey, we'd like to make a rule about, emailing people on Sunday, and we're going to say that that's illegal from now on. We have to have a specific statute that where Congress said, hey, we want you to make a rule about this, and COPPA just is one of those. So there was a Child Online Privacy Protection Act, and that's COPPA, and that's where our rulemaking authority came from. So I guess someone in theory could say, hey, you guys exceeded your statutory authority with how you amended this rule. Someone could challenge us that way.
But the answer is the lawsuit.
Yeah. I mean, this has been such a long process, and there have been actually lots of changes in response to the comments. And because this was the proposal in 2011, I would not take that to mean that that's where this is headed. I think there were a lot of comments, and those are being very carefully considered.
I just want to throw in that I was notified the day before comments closed and asked to comment through Act Online. And so if you go to Act Online, I think they'll have a lot of information about. They've presented here before about what's going on and how you can make comments in the future.
Yeah, there are a couple different, obviously app developer trade groups that have been involved in the process and have made comments among many others. And you can also, if you want to see the comments, there's a list of them. There's always a list of public comments that we've gotten for a rulemaking, and you can see a list of all the comments, and each one is a link. So if you're just wondering what different companies have said, because pretty much everybody you would think would weigh in on this process, you can always check it out and see what kind of comments we've got.
Is in-app purchasing considered to be an illegal process or?
Right. So some of the questions that we got, we should definitely touch on this, because I know Josh actually pasted them into the end of my PowerPoint somewhere, and we'll talk about in-app purchases, but I made a promise to take those out because I don't want you guys to think that I thought you needed to answer those questions. But we will talk about those, and then I'll tell you about some other general resources that we have that might be helpful to you. So in-app purchases is not, strictly speaking, that's not a COPPA issue unless a purchase is not itself a triggering event for COPPA. You need a credit card number, but you're going to be probably collecting, if you're collecting a name, that's going to be personal information under the rule, right? So if you're making an in-app purchase without collecting any of the personal information on that list, it's not a COPPA triggering event, right? But if you're giving a name, it doesn't matter that it's not the kid's name. If the kid is the one giving the information, that's a COPPA collection of information. The credit card information is a funny thing because that's the rule. We kind of presume that if there's a credit card number being given, that's a parent giving it. Yeah, that you have to be. That it's an adult giving it. Those of you who know about how to verify that it's a parent giving consent. Giving a credit card number is one of the ways that you can verify that it's a parent giving consent. So typically, getting it just a credit card number does not indicate to you that you're collecting information from a kid. Of course, there can be issues of deception and other problems with in-app purchases if you're not making it perfectly clear what the charges are going to be. That's not a COPPA-specific issue. That's across the board. We've had lots of cases where we're like, hey, you didn't tell people they were subscribing to 3 years of your service. So there are things like negative options, things like that, where we've alleged law violations. Other questions? Yes.
So talking about triggering events, you said that the site needs to be directed to kids, right?
Or a general audience site with actual knowledge. Those are the 2 ways. So directed to kids, collecting personal information, that list we went over, or a general audience site with actual knowledge that they're collecting information from kids.
So my particular case we're working on, and I think it's kind of general as well in some of the kids-directed applications, is that you're trying to have a section of the app, in this case, or the site, in this case is an app, that the kid is going to be playing with. In that section of the app, there's not going to be any capturing of information whatsoever. There's just going to be playing data. But then there's going to be a button that's going to say, this is only for grown-ups, or this is only for parents. And then you're going to go into that section where the kids shouldn't go, and then you're going to collect some information about your kids.
Yeah, the rule, it sounds like you're getting at a scenario that was envisioned by CAPA, which is that you can have a child-directed portion of a site. We're still going to look at it and make sure that it, that we agree that it's child-directed. We sometimes are skeptical of these things, but it sounds like you're talking about something that's not an uncommon practice, which is to have a child section of the site where parents can visit, and you'll have a privacy policy explaining, hey, we don't collect any information from your kids, but then a separate part that's not directed to kids. So we'd just be looking to see if you had actual knowledge of kids, using that part of the site.
So is there a standard? I think this is a big question for a lot of us, where we have the parents part. Is there a standard that CAPA or your execution of CAPA would consider reasonable security against the kid getting into
we've never had a case that was about this, we've had actual knowledge cases, like I was saying, where people collected date of birth or other information that gave them actual knowledge kids were giving their information. But we haven't had a case that was about the segregation between, adults part of the site and kids part of the site. I don't know of any bright line rule, but it's just like, the question of, is your site directed to kids? It's going to be the same kind of analysis.
And when we say sites, apps are the same thing. We've got a section of the app.
Yes, I'm sorry, I keep saying website. So it's website or other online service. For some reason I cannot get myself to say operator, because I'm like, well, no one knows what that means. But yeah, site, generally, site or other online service like an app.
And you said there's been no case yet, and there's no bright line definition, but none of us here want to be that first case.
Right.
For anybody who, I don't know if anybody else has been in front of COPA, but it's not a pleasant process.
You want to make it clear that that part of the site is not directed to kids, and you know what the factors are for when it's directed to kids. Like, does it have activities and models of the kid's age and things that would be appealing to kids? It sounds like no. It says for parents. It's going to be fields where they could do parental activities. But I think it is a best practice, a very good idea to have some sort of gate to get into that site, right? So have something that the kid would have to do that's not just as easy as clicking a button. Because if you're on a child-directed site doing activities, then you can just click a button and get there. You're already interacting, so you might not.
So that was my next question. What about if we put some kind of baby gate, or we put some kind of puzzle or thing that an adult can? That just the kid is not going to be so easy to enter that. And then, but even then, there might be. This is up to 13-year-old, right? So a 10-year-old can resolve the puzzle, and then can enter the parent section. The parent section, you can be signing up for a newsletter. You can be sending your kids' ages. You can be sending your kids' names. Would that trigger an event with COPA?
Yeah, not if it's. If it is like a kid's site. So if kids are easily just clicking on it and starting to enter their information. It could be a problem, but it sounds like what you're saying is it's really just there is a part of the site that's not child-directed, and the rule explicitly contemplates that and talks about if you have a part of your site that is child-directed and a part of it that is not. So it's something that the rule envisions you are able to do, but I think it's a really good practice to make it not as easy. If you're just clicking around to play the game, you don't want it to be just that easy to get into this other part of the site. So you'd want to have some sort of way to limit the exposure. Yeah.
There was something, the reason to know that came up, I think, with the recent proposal.
Yeah, so this is the proposal too. This is actually really kind of complicated. Be entertained by this. Hopefully I'll get it right. But don't worry about this. This is not the current obligation. So there is if persistent identifiers are covered, there is the potential that, say you are a website that is child-directed. So you are collecting you're collecting information from kids, and persistent identifiers become covered. So IP address or cookies, who knows what they might be, because that is not the current rule. This is just a proposal. And then say you have something like a plugin on your site, whether it's a like button or another button, and that also gets the IP address of someone who visits your site. A question came up, well, gosh, we don't even know, for those who provide things like, buttons or links to post things on social networking sites, well, gosh, we don't know that we're being posted on a child-directed site. We don't control who puts one of our buttons on their site. We have no way to know. And so there was a proposal to say, well, if you have reason to know that you're operating on a child-directed site, you could be liable. There was a lot of commentary,
But that came up also in the context of the App Store. The App Store, especially Apple, reviews every app. And my understanding is, as part of the rule, Apple could be liable for every copy violation.
Yeah, so that wasn't really clear that was, I don't know the details of that proposal, but it wasn't clear, I don't think, that platforms like stores would be liable under COPPA. I'm not sure. So there was this, the way that you become an operator is if you are collecting or maintaining information, or it's being collected or maintained on your behalf or for your benefit. And there was this line in the proposal that said, actually the supplementary proposal in 2012, that said, if you're putting content on your site, like these buttons, that information is benefiting you because it's populating your site. So it was suggesting, like the reverse of what I was saying. It was suggesting you could be liable if that button is doing something to collect kids' information. You could be liable because it's benefiting you that you have those buttons. People want to use your site because they can post to Facebook or Twitter or whatever it is. But I don't know that there was anything that suggested something similar would apply to platforms. I would wait. I wouldn't get too far ahead of the rulemaking process on any of this.
I'm sure you will demonstrate that.
Yeah, no, I know that a lot of comments have actually gone out, to the best of my knowledge, about this particular thing, because it basically, if that were to be the case, then every app that is targeted towards a 13-year-old could just be shut down by Apple.
Right.
That's why the risk of being liable.
Right. I
So
think there was a very spirited comment process about this, and to try to press the commission to say, hey, what are you really concerned about? If you're really concerned about, for example, online behavioral advertising, which we have expressed a lot of concerns about privacy, that there should be, how many of you have heard of the general Do Not Track initiative that the W3C is working on? And the FTC, we said in our own, unrelated to COPPA, our own general privacy framework, we said, there should be a do not track so that consumers have a choice to turn off behavioral advertising. And there was some effort to address behavioral advertising to kids when they're being tracked across different sites, that this should be a COPPA issue and parents should have a chance to say no to that. And you can sort of see, at least keep them on a par with what adults are going to get through this voluntary process. But obviously the way it was proposed had very broad implications. And there's a lot, like I said, many comments were received about that, and lots of comments saying, there will be no more plugins, there will be no more apps. So I think there was a lot of concern, and I think, people are carefully considering those comments.
I have a question about the line of responsibility. If you have an app which either takes a link out to someone else's app where they're doing stuff, I would imagine that once it goes there, they become the operator. And similarly, if you have an app, for example, where you have an SDK which has code from another person, when the child is involved with that portion, are they considered the operator?
So these are two very, very separate questions. Because the rule actually says, and this is the current rule, the current status of things, it actually says just posting a link does not make you liable as an operator because of what might occur on that site should a consumer click that link. But by contrast, if you're using a software development kit, if you're incorporating code into your app and that is resulting in the collection of information, that will absolutely be attributable to you. That's your app and you're the one using that code.
Collecting personal information.
Yes, correct.
So back to the question of sort of that wall between the parent area and the kids area.
The question I'm least able to answer is
I'll keep asking again. So, like entering your personal information, if in that parents section it's a connect with us on Facebook kind of button, which then takes them outside the app, how does that relate? Is it again just as long as it's kind of buried far enough along the parent channel?
Well, under the current rule, that would be more like placing a link on your site. So if you have a button that says connect on Facebook, that's not going to take a child to anything. it's not going to set them up with an account that they shouldn't have on Facebook or do anything. It's going to take them to the Facebook login page. So that alone is not going to be a triggering event under the.
So you could have that in the child's area, and you're not triggering.
Well, you
don't want
shouldn't
to,
do that. Yeah, you shouldn't do that. That's not going to look great. That is not going to look great.
And that's also not in the proposed 2012 language either.
Well, so I actually don't. So the issue in the proposed 2012 is whether a persistent identifier that would be transmitted to a plugin would be covered as personal information. There's some question about that.
So, for example, I give my iPad to my son to use. I'm already logged into Facebook. He goes down the parent path and says, connect with us on Facebook. He's in my account, of course.
Right. And he's the one submitting the
So,
information.
but that...
Yeah. I mean, in that case, I don't want to play too many hypotheticals because there could be other facts that could be filled in and make me say something different about this. But in that case, you're signing into someone else, your parents' Facebook page, and they had the opportunity to log out of Facebook. They're
So in fact, your parent has signed in.
I would not think that would be your issue as an app, but yeah.
And is there any do you spend a lot of time on iPhone apps or Android also the same kind of?
The same situation, the same kind of, the exact same analysis.
Because Android apps, anybody can put the apps out there without much streaming. So, do you spend equal time on both or more on the iPhone apps than Android?
When you say spend it, what do you mean spending time?
It means finding the irregularities.
So we did this survey where we looked at 200 kids apps on Android and 200 on Apple, just to see what the privacy practices were of different apps on the site. And we looked at the disclosures that you could see in the app stores or by the developers, and just found that you couldn't really, in either store, find anything much at all out about their information collection practices prior to download. And we said in that report that we'll be following up to see if any of those apps, in fact, are doing anything that might be, problematic and not disclosing it to parents in advance. So we look at both. Certainly, we look at both for compliance and to see what the practices are. So,
what was the comparison like?
You mean the exact numbers in the report?
Who was more compliant, more disclosure?
I think they were, the title of it was Current Privacy Disclosures Are Disappointing. And I think the general idea is that there was very poor compliance in both stores. Very few. I can't remember what the percentage was from the report. It says it in there, but it was a very small percentage. Gave any meaningful information before download about what their practices were. Yeah.
Do you have any good references or templates for what would be a good privacy policy?
So there's if you go to, there's a business.ftc.gov website. Can you guys take out that? I just want to, if you go to that website, there is a children's privacy area. And then the other thing I put up, there's a kids microsite. If you go to ftc.gov/privacy, so there's a couple different ways to get there. You can search for COPPA on ftc.gov or go to business.ftc.gov and go to children's privacy. There is a privacy policy checklist that goes through the elements of what has to be in your privacy policy and asks you questions to help you figure it out. I think, my understanding, and you guys chime in, I think there are actually quite a lot of online resources, non-FTC.
I think Act Online has a privacy builder that takes you question by question and gives you a template and things to think about. You have to sign off on them yourself, but it's a good starting point.
Yeah, and the thing you don't want to do that a lot of companies have done, unfortunately, is copy a privacy policy from someone else. Obviously, you want it to reflect your practices.
Privacychoice.org. I'm not sure who asked that question.
So, in terms of the questions that people wrote in, at the end, I grouped them by 5 major topics. We've already touched on a couple of them, so maybe we could just look at the big picture topics.
Okay.
The first one, kid-parent segregation. We spent time on that. Does anyone have any additional questions about that? Okay. one was, let's see, next page. In-app purchase. We started talking about that. It sounds like that's not a COPPA issue, really.
Yeah, not yet.
Yeah.
I mean, if purchasing involves giving personal information, it would be a COPPA issue, but not in.
Not through the popular Apple App Store route, for example, Apple's version where.
Right, where you're just giving a password. I mean,
there
there could be other issues, and a lot of the app stores, frankly, have cracked down on this because they don't like parents calling them and saying, "I'm not paying for this later."
So any other questions about that topic? Yes?
Yeah. Is there any relationship between I mentioned this to you before, CARU, the children's advertising regulations, and what's happening in apps?
So you mean CARU, the safe harbor?
CARU, whatever it is, children's advertising regulations.
They provide one of the 5 safe harbors. I don't remember what there it is. I know they provide one of the safe harbors, but I don't know what is the other thing that they're working
on? It's what governs all advertising towards children on TV and print and online.
So I'm sorry, I must be losing my mind. What was the question?
I'm just interested in if you're trying to make some kind of connection between general advertising rules for kids that exist outside of the app space and the app space.
COPPA doesn't really allow us to do that. COPPA specifically applies to the online environment, so it doesn't apply to something that's not a website or online service. It just doesn't. It can't reach that. We don't have the authority to reach it. The law doesn't allow it. So if you're saying like, hey, we'd like you to go and take a pen and a piece of paper and mail us a postcard with your name, birthday, social security number, it doesn't apply because it came in on a piece of paper. I mean, it just is that bright of a line. COPPA just applies to online collection.
Just to clarify,
the other big topics we were on. Yeah.
And there was a question in the back a while ago. Did your question get answered?
No, I had a specific question, which was, if say in a typical use case with app game is you're displaying a user score, it would be a child score, and you would be collecting. You would be asking them, a name to be associated with the score.
Right.
Now, the intent there is they could be putting in their full name. Now, is that also considered as other?
So my understanding is if you actually end up collecting full name, yes, it's covered. It just is. It's a bright line. You're collecting the full name. But if you're having them just like, for example, giving a first name, is it okay? So you could do something like we want you to pick a name. And if you prefer it not be a real name, you could tell them that. But also you could just make it so there's only one field, so they can't enter a first and last name, or at least make it a lot harder for them to. Yeah.
So one of the things that is a big trend is around gamification and social within the apps. And if, say, a parent enters in the email, the name of the kid, and their ages, and there's a competition, say, to compete to see who can answer the most questions in a trivia game, for example, is that okay to do if the parent enters in that information, or is that considered a violation?
Yeah, so the question is, if the parent submits the personal information about the kids, like the items from the list, but you later combine it with other information that you're collecting based on a kid's activity, is that right? So I think the answer is it makes the additional information considered to be personal information. So you want to make sure you're already communicating with the parent. You might want to just tell them what it is you're doing, and then you'll have met your consent obligations under COPPA. Because anytime when you are going to combine other information with a name and address or other items from the list, it's going to make it a new type of personal information that you're collecting. Does that make sense? I mean, it sounds like a lot of these games, I know somebody wrote in a question where they said, well, we're doing an educational game and we want to tell the parents like which math skills, they need to work harder on, or how their kids are doing, or, that they're ready for the next level and they should buy them that game next, or whatever it is. And in that case, like, you're not going to have, you're already going to be communicating with the parent and you're not going to have a problem. But if you're going to want to, identify it and link it to the kid's name, you should probably get the parent's consent. I mean, there might be ways you can do it just using the parent's contact information.
So as long as it's in the consent or it's in the privacy policy, then that's okay to do, and you're protected in there.
Yeah, I mean, you always have the option when you have a gray area to just comply, just do the COPPA compliance procedures. If you're in a situation, you're in a great situation. If your business model is that you're already interacting with the parents and they're happy, they want the kid to do that app. I mean, you should just. I would probably think it's best to just comply as if COPPA applies, and then you don't have to worry. Yeah.
Just out of curiosity, what happens if somebody signs up to your website and what a lot of people will do is just give you a random email address, which is clearly not an email address? How does that fall into the privacy of the information? Because you can't really clearly confirm because that's not about that. So there's no confirmation that can come through. It's clearly not really an email because it's bounced. So that information you might have, even though it might be private, really you can't connect it back to anybody.
I mean, that is one of those kind of funny questions because I think technically we could, if we wanted, make an argument that it's covered because we certainly can say if what the kid is giving you is, if it all turns on COPPA, it all turns on who's giving you the information, right? The kid has to be giving it to you. Someone who is not the kid, who is that kid's older brother or sister who's 18, could give you all the same information about a child and COPPA doesn't reach it. So, but for the times when you are collecting information from a kid, it doesn't specify whose name or address or other information. So if kids are giving information about their grade school classmates and giving their address or somebody else's name, you're collecting personal information from a kid. I know.
So let's assume the only key I have you would be collecting is an email address.
Right.
And that email address is non-existent.
Yeah. I mean, the fact is you're going to have a broader issue if you're collecting email address because that is a covered. I mean, it might happen that someone has given you an incorrect one, and that alone is not an appealing case for enforcement. I mean, while it does raise a gray area, collecting one email address is not going to make us say, "Whoa, we need to take action." You know what I'm saying? So, but if you have a practice across the board where this is happening frequently and it doesn't fit, we can talk about the exceptions. There can be those ones I mentioned earlier, examples of the exceptions, just collecting email address. You're going to want to apply.
So do you have a code level, I'm sorry, do you get a code level access also for testing the apps? Because it's a standalone app and then some apps can be doing something in the back end, so like you can't see in the front end. So these kind of things like does Apple and Android give you access to the back end of those apps to see if it is communicating with their own servers in the back? Or?
So I don't know what Apple and Android are doing. Is that the question? What are Apple and Android doing?
Means like sometimes you may have a standalone app. It's not doing anything else. Just some starting information there, just collecting and then skipping the app. Some can be communicating that information back to their servers. So how, like when you see the app, you can't see what it's doing in the back end. So do we get a code level access of those things, what it's doing?
So when you're saying you can't see the app, who is you? That's what I don't know.
I'm like a FCC, like a what? The user, like a...
Are you asking if the hacking to the app to find out what's going on?
It's not hacking, like the app can be like if you're entering information like a name and something, which is a standalone app, it's not doing anything else other than storing the app information within the app. Some apps can communicate back to this information to their web servers. So is that like
this is about the person who made the app. So if your app is communicating things back, you know about that.
Right. But how they will know that this like this is getting communicated like a.
Well, I think he's asking how does the app if my app is secretly doing stuff, how do you guys know to prosecute and fine us?
Right. Yeah. I mean, it's all different kinds of ways we find out about things that are going on. Like sometimes one app complains about another. We're not, have some kind of like universal spying apparatus. It's nothing like that. It's nothing, but a competitor may complain about you. Sometimes former employees contact us. Somebody, you're collecting information. Typically, you're not doing just nothing with it, and the way that you're using it attracts somebody's attention. I mean, to be honest, like a case where you're just sending information to a server and nothing's happening with it is also not the most interesting case to us. I mean, so typically it's because companies are collecting it and they are doing something with it.
So if we can go back to the big picture, so in-app purchase, so to make sure we get through some of this stuff, can we skip to the next one?
Yes.
Ads. So we talked some about ads.
Yeah, I think we kind of covered that, right? Because we talked about the analytics and the questions we asked. Yeah.
I have a question around collecting. You mentioned that if it's still the mother of the parent, giving all information about the child is fine. So if you put this behind
it's a very funny thing, but yeah.
So if you put this behind the parent portal, like, what kind of measures do you take to make sure, or do you have taken measures to really make sure it's parent, or is it just saying the parents only tab and
Parents
yeah. So yeah, I mean, if you feel that you have made a separation that is adequate, so that it's not just this if it is a seamless line to get from this is back to that question of segregating the apps, which I'm probably doing a terrible job answering. But if it is a really seamless single click to get into the parents only sections, that's probably not going to be good enough. So I mean, I think you just need to people made some really good creative suggestions about somebody was saying, well, have them enter some piece of information that maybe a kid wouldn't know, or have them follow a command that a kid might not read, like a kid who's just clicking might not know that they need to press and hold the button before to get to that bit. So it's not incidental that they go there, and maybe don't make the first screen that you get to on that page the spot where you enter your information, that kind of thing. So that they would look at it and think, oh, well, that's just a text page. I'm not interested in that. And have a button return to app or something like that.
Or your birth date, are you older than 13? If yes, then you can enter this area. If not, then this area is locked down.
Yeah, I mean, usually we don't like to see it act in a leading way like that, although I think there's recognition that people try again on some sites and get through the second time. But it's, since you're not going to be making this an attractive site to kids, it should be okay.
We skip ahead. So there's just a couple more. Data collection and analytics. We talked about that. Does anyone have any more questions about analytics?
Yes. So if I'm looking for an individual vendor who does analytics, and you talked about safe harbors, if I want to find a vendor that is, COPPA compliant, are there any fields or something? They might be stating they're COPPA compliant, but is there something that I should be looking for in a vendor? Is there something?
No, that's a really good question. So again, with the proposal, we're suggesting that you should, take reasonable steps to make sure that they are compliant. Right now, under the existing rule, we just say you have to have reasonable steps to maintain security, which we could extend to that, but we haven't made that explicit. I mean, it's a good idea to know something about your vendor. If you are a very small company and your vendor is a very large company, we do not expect you to audit them. We don't expect something that is out of all proportion to the business setup. But we'd expect you to know something that's obvious, like that the company had a terrible reputation and had lost its trust mark and wasn't willing to sign a contract agreeing to comply with COPPA. Most companies that are going to provide services to a kid-directed site should be willing to agree to that in a contract with you. So.
Any other analytics questions?
Is it against COPPA to incentivize parents to let you collect information on their kids, like saying if you agree to this, we'll give you a virtual good or a coupon or something? No.
As long as it is true what you are saying. Yeah, you can't say we'll make your kid get an A in math if you agree to this app and then not really live up to that.
I'm actually here. I know Yogi Play actually asked a question in this vein, and how does it work with Yogi Play and some of the newer people that are really just about analytics? That's one of their key focuses is to give parents just the inside data on what's happening within that app. Is that completely?
You mean to give back to the parents?
To the parents, yeah.
Yeah. So what would you be collecting that's personal information? You'd be collecting just the parent's email address?
I think she's asking Michelle.
I can tell you personally that the only personal information we collect is the email address.
That's what I'm saying. Because you're only getting the actions, there's no personal information, then there's absolutely no.
It depends. I mean, so internally we do make the association between the actual events that are happening to the user, and then we show that information back to the parent. But all of that is missing within YogiPlay. We don't give any of that information to any third party. We do some analytics, which is aggregate analytics, any personal information extracted out of it, so we don't know anything. Once we do any information that aggregates information, everything personal goes out the door. So we look at the data, we look at the demographics. I can tell you that there's 3 years old and 4 years old and 5 years old, but I cannot tell you from that aggregate anything about the user underlying that data. So as far as we do, we're very confident that we comply to COPPA. Now anything can happen. That's why I'm interested to see what is happening within the laws and how things are changing to make sure that we continue to comply. But we do everything in our power to make sure that we are compliant. So everything behind the parent interface requires a login with a password. Even though they don't really go anywhere except for seeing the child's progress, so there's not much for them to see as a child, but we make sure that anything that communicates back with the parent is, and that's why I'm asking about the email, because, for me, that's the one thing that I collect, and sometimes I do communicate with that email address. That is my point of contact, and I'm like, well, if that information is invalid, I don't really know where I fall as far as that goes, but I think I'm safe, because I'm safe when the email is correct, so I'm safe on that front, but, just need to be careful and watch out.
Yeah. I see what you're saying. Yeah, in the context of it, if you have a COPPA compliance program, and you're getting email addresses to get consent from the parents, and then, you can't get consent because you've been given an invalid email address, you would just treat it like as if a parent declined to give you consent. You would delete the information, right? Because it's not valid anyway. So you decline.
I'm not sure if that was the last one.
You kind of got to all these things in the natural discussion.
That's great.
Yeah, I think you asked about it.
Someone asked about Game Center. If an app uses Game Center and an app developer lists their own privacy policy on their website saying that no personal information is collected about users, including children, is there a conflict here?
I don't know what the conflict would be. This one's not spelled out clearly enough. I don't really get it. So if you're an app and you're not collecting information.
But I'm using Game Center, and to sign into Game Center, I'm giving information, because that's the Apple part of it.
Oh, but you're not. So remember the test for when you're an operator is if you're collecting information, it's being maintained on your behalf or for your benefit. There's no indication that that is happening when people are signing in to get to your app. You're not getting that sign-in information. You're not collecting it.
No, Game Center is different.
Oh, okay. Yeah.
Game Center, I haven't played on with it much, but you actually have to give your information about the users, which can be adults, it can be kids. So some apps use that as their collection mechanism in order to keep track of scores, and
so is the question
that information can actually be shared across all of the apps that are using that particular that Game Center, so I can see the top scores for all the users of this app. So the information on scores now becomes public.
I see.
So
if the question is, hey, the way the Game Center, where my app is located, the way it's set up, Game Center allows kids' information to be disclosed publicly?
Potentially.
Potentially. I mean, if that is happening through your app, you need to consider yourself an operator with regard to that information. If it's personal information, if it's just de-identified information like player one, then it's not.
Did the person who asked this question, are you here? No. But I think Game Center is the username and password. But my child could put her first and last name as her username if she created that account.
Right.
But it's an Apple mechanism. It's not, I think that's why they were asking. It seems like a prayer.
But it doesn't collect, I believe, as an operator in this case. I don't know the full name or email addresses. All I know is a unique ID that's owned and maintained by Apple.
Yeah, I don't know enough about how Game Center works. Like if it checks, because it knows your real name, but if it checks to make sure that your username is not your real name, I don't know.
Well, it's targeted at over 13 because you can't sign up for an Apple account if you're under 13. And so it makes the assumption that this is an adult signing up because they've taken appropriate action to age gate. And so they're assuming that,
So basically you're making the assumption that the parent is the one who signed in.
Yep.
And then the kid might be the one tracked, but the parent has create the account in order.
Yeah, I would get, if you think that there are kids using your app, I would get consent for what's going to happen for your app.
So I have a question maybe for general audiences too, is that does Apple plan on having like a sub-account like specifically for kids? Because I'm not aware it exists right now. Because we dealt with this problem at Electronic Arts years and years ago, where we have, we consider all those corporate issues, and we end up having like the regular account, but also a sub-account that's tied to the parent. So I'm actually eager to, as you pointed out, it's kind of a conflict where the app, kids could just go into Game Center, but the Game Center account is tied to an adult account. So what's going on here?
From my understanding, the FTC is actually, telling Apple to, hey, consider this use case.
Yeah,
it's not in their interest.
Everybody.
It's not in their interest because they're not necessarily nothing's being enforced in that case because they're taking every appropriate action in accordance with COPPA. So for Apple to do the right thing, maybe, but as far as in guidance with what's provided by the FTC, they're fine. It's fine. That's a good point.
Quick follow-up to the one question.
Well, I just want to make sure people have time to mill a little bit because we really should be out by 8:30.
I'll make it very brief. So we talked about the case where we include third-party SDK inside the app. The question was about responsibility. Because our application we use your own data. What should our privacy say?
So, your privacy policy, if what? If you are collecting what?
No, our application doesn't collect anything. We do use a third-party SDK that includes what we collect information.
Yeah.
Our privacy policy includes everything.
So yes, if a third party is collecting information through your app, you should disclose that to be truthful under the FTC Act. You should explain that. But it sounds like that information is not going to be personal information at the top. It's not going to be the name, things like that.
It's actually we use an SDK that is COPPA compliant.
Oh.
And the way it is spelled, if your app doesn't collect anything, it will only collect stuff that your employee wants to consent. Okay. And so the candidate's consent, nothing will happen.
They want to describe how it operates. So, it has a way that it operates, and like it explains what it makes our privacy policy.
We will address it pretty quickly. Basic skill, case managers close by. Really nice, easy to work with.
We took a video, we'll try to post it for people to view, and I'll be sending out the presentation probably tomorrow. Thanks to everyone.
No, the site isn't shut down. As far as the patterns and processes that we use, but also things right now, they're not really documented anywhere because they're publicly PR or anything like that. But if you have questions, I'd love to.
I think we have actually.
Ken also, Ken, he's our lawyer, yeah. Oh, that's great. He recently moved first.
Yes.
Yeah, Ken's great, yeah. If you're talking about detailed product, is that what you're asking?